The auctioneer's gavel was falling. The highest bidder was already reaching for his pen to sign the cashier's check. But as the wood struck the block, a single mother of three didn't cry. She didn't scream. She simply stood up at the back of the room, holding a yellowed piece of paper sealed in a Ziploc bag, and spoke 6 words that stopped the sale of her 160-acre ranch dead in its tracks. The mineral rights are not yours. The Texas Panhandle doesn't forgive mistakes. The land out here, just 30 miles east of Amarillo in Donley County, is a hard, flat tabletop of caliche soil and whispering bluestem grass. It's country where the sky is so big it bullies the horizon, and the only thing that moves faster than the tumbleweeds is a banker's pen when the interest rates spike. Lydia Marrero knew the rules of this land. She learned them from her father Tomas, a man who could taste rain in the air 12 hours before a storm arrived. Lydia was 42 years old, with lines around her eyes that weren't from age, but from the specific gravity of holding a family together when the center is falling apart. She wasn't a speculator. She wasn't a developer. She was a widow, 3 years removed from burying her husband after a collision with a semi on Highway 287, trying to run 200 head of black Angus on a ranch that had been in her family for 5 generations. The trouble didn't start in 2023. The trouble started in 2020 when the pandemic choked the supply chain and the price of beef futures jumped sideways. Lydia had taken a variable rate loan on a piece of equipment, a John Deere 8R410 tractor, to upgrade the haying operation. The loan was held by a regional agricultural lender named PlainsWest Capital. For 2 years, she never missed a payment, not one. But in the fall of 2022, the Federal Reserve raised rates at the fastest pace in 40 years, and that variable rate note ballooned from a manageable 4.1% to a strangling 11.7% almost overnight. Suddenly, a payment of $3,200 a month became $7,800. Lydia did what every rancher does. She sold off 30 head of heifers at a loss. She drained the emergency savings account, all $17,400 of it. She took a night shift at the cargo beef processing plant in Friona, working from 6 p.m. to 4 a.m., her hands freezing in the cold chain locker, just to keep the lights on. But the math was a loaded gun. By March of 2023, PlainsWest Capital sent the acceleration letter, declaring the entire principal balance of $418,000 immediately due. Her mailbox became a countdown timer. Notice of default, April 3rd. Notice of sale, May 17th. The auction was set for 10:00 a.m. on July 19, 2023, on the grimy granite steps of the Donley County Courthouse. The single mother loaded her 3 kids, Michael, 16, Sophia, 14, and little David, 9, into the cab of a battered 2004 Ford F-250. David looked at the courthouse columns that morning and asked his mother a simple question. "Mom, why is the bank kicking us out if we live here?" Lydia had no answer for him. But she had something else. She had a cardboard box that her father had given her 6 hours before he died in the cardiac wing of Northwest Texas Hospital. "Don't open this," he whispered, his voice thick with morphine and dust. "Not until the ground shakes, not until the vultures land on the fence post." At 9:55 a.m., standing outside the auction, Lydia tore the tape off that box. Inside, wrapped in a leather chamois, was a warranty deed filed at the Donley County Clerk's office, Book 142, page 67, stamped September 11, 1973. It was a document that didn't just transfer the surface of the earth. It contained a reservation clause so archaic, so bulletproof, that it made the $418,000 debt look like a rounding error. The vultures had landed. The ground was about to shake. The foreclosure auction of a rural property in the Panhandle is a somber affair. Nobody is clapping. Nobody is excited. There is a specific etiquette to attending these sales, the kind of grim formalism you see at a funeral where the family didn't have enough money for a casket. The trustee for PlainsWest Capital was a man named Gerard Finch. Gerard looked like an accountant, which is to say he looked like a man who had never sweated in his life. He stood on the top step, holding a clipboard, shielded from the sun by a pillar. Gerard read the legal description in a monotone drone, a string of metes and bounds. Beginning at an iron pin on the north line of Section 42, Block H, G and M survey, then south 89 degrees west. The bidding started at $250,000. A lean man in a gray suit, representing a mega ranch conglomerate called Red Basin Holdings, bid it up to $380,000 without blinking. Another voice, a local buyer with dirty boots, pushed it to $405,000. Red Basin, wanting the water rights and the contiguous access for a wind turbine lease they were negotiating with a utility company, countered with $425,000. Going once, going twice. Lydia was standing at the back, next to a rusted water fountain. Her heart wasn't pounding. It had slowed to a resting crawl, the kind of bradycardic calm that overtakes a person when they realize they are holding a weapon of mass destruction that nobody else knows exists. As the trustee inhaled to shout "sold," Lydia walked forward. The crowd parted, not out of respect, but because she was holding the deed in front of her like a crucifix in a horror film. The paper was yellow, brittle at the creases, covered in courier font from an IBM Selectric typewriter. "Stop the sale," she said. Gerard Finch looked up, his expression a mixture of pity and annoyance. "Ma'am, the bidding is closed. The property is sold subject to the lien." "The lien on the surface estate," Lydia replied, her voice steady but amplified by the natural acoustics of the stone portico. "What about the mineral estate?" Finch laughed. He actually laughed, a short, dismissive puff of air. "Mineral estates don't halt a foreclosure, Mrs. Marrero. The bank's deed of trust covers all appurtenances. We've seen this delay tactic before." But Lydia didn't waver. "You haven't seen this deed before." She handed a photocopy to the constable standing by the door, Deputy Hale. The deputy was an old man with a walrus mustache who'd known her father. He adjusted his reading glasses. He read it once. He read it twice. Then he looked at Gerard Finch with an expression that can only be described as apocalyptic amusement. "Mr. Finch," Deputy Hale said, "I think you need to adjourn this sale and walk inside to the recorder's office. This 1973 warranty deed reserves all oil, gas, uranium, and other mineral substances lying in, on, or under the described tract, unto Tomás Salazar Marrero, his heirs and assigns forever. And it states, hold on, it states that any transfer of the surface without the explicit joinder of the mineral holder is voidable at the option of the mineral holder." The silence that followed lasted a full 12 seconds. In rural law, 12 seconds of silence is a lifetime. Red Basin Holdings, lawyer, who had been leaning against a silver Merced Sprinter van, snapped his head up like a coyote catching a scent. Lydia didn't own the house because the bank said she did. She owned the house because the mineral rights, worth an estimated $1.2 million in an active helium and natural gas play, had been severed from the surface 50 years ago, and the bank had never, not once, checked who owned the gas beneath the boots of the foreclosure. To understand how a Panhandle rancher outsmarted a Wall Street-backed lender, you have to drive backwards in time to 1973. Watergate was on the news. The price of beef was frozen by Nixon. And Tomás Salazar Marrero was a man obsessed not with cattle, but with the gaseous geologic trap sitting 4,000 feet below the caliche. Tomás was Lydia's grandfather. He bought the original 160 acres of the Marrero Ranch in 1952, but he didn't just buy it with a handshake. He bought it from a lonely bachelor named Clifford Hatch. Clifford was 81 years old, had no children, and had a deep, paranoid suspicion that the federal government was going to seize his land to build a Titan II missile silo. A fear that wasn't entirely irrational in the Cold War flats of the Panhandle. Clifford was willing to sell the surface. He wanted to die in a nursing home in Amarillo with air conditioning and jello, and he needed cash to pay for it. But Clifford had an obsession of his own. He didn't want to sell the underground. He believed, prophetically, as it turned out, that the land was rich in helium, a strategic resource that the Bureau of Mines was stockpiling. Clifford made a demand that his lawyer thought was eccentric. "I will sell the grass, but I keep the ghosts underneath it." On September 11, 1973, in the wood-paneled office of attorney J.D. Merkley in Clarendon, Texas, the deal was struck. Tomás Marrero would pay $28,000 for the ranch house, the corrals, the water wells, and the grazing rights. But Clifford Hatch would execute a separate warranty deed, reserving all mineral rights unto himself. Here's where the trap was set, a trap that took 50 years to spring. Clifford died in January of 1974. He had a will, but the will was vague. It said, "My mineral interests I leave to the kind man who bought my ranch because he promised to fix the windmill." Tomás was that man. The will was probated in Donley County, and the probate judge, a man named Royce Blackwood, issued a decree of distribution in April of 1974, vesting the 160-acre mineral estate directly into Tomás's name. Not the surface, just the minerals. For decades, this was just a piece of paper. The ranch made money on cattle. Tomás paid taxes on the surface to the county. He also paid a separate tax bill, just $2.13 a year, to keep the mineral account active. He never leased the minerals. He never drilled. He just waited. In 2021, when PlainsWest Capital wrote the loan for the John Deere tractor, their title company, a high-volume mill in Dallas called Verity Title Group, ran a perfunctory title search. They saw the surface deed. They recorded the deed of trust against the surface. But in the legal description of the collateral they wrote, 160 acres, more or less, Donley County, Texas, including all improvements and easements. They never typed the word minerals. They never searched the severed mineral estate index. It was a $418,000 mistake that a first-year landman could have caught in 15 minutes. The bank thought they were foreclosing on dirt and a ranch house. They were actually foreclosing on a cork, and the bottle underneath was worth 3 times the debt. Why does a 1973 deed matter so much in 2023? It's not because of oil. There's plenty of oil in the Panhandle, but the Marrero section is flanked by the Hugoton Panhandle gas field, a geologic monster that has produced so much gas over a century that the only thing left in the deeper dolomite formations is the lightest, most strategic element on Earth: helium. Helium-4, the noble gas, the coolant for MRI machines, the purge gas for SpaceX rockets. The stuff that makes your voice squeaky at a birthday party is also the one element you cannot artificially manufacture in industrial quantities. It's created by the radioactive decay of uranium and thorium over 1 billion years, and it accumulates in the same geologic traps as natural gas. 2 miles beneath Lydia Marrero's porch, the cliffside formation was a helium reservoir with concentrations between 1.8 and 2.4%. In 2022, The price of crude helium had surged by 140%. Unbeknownst to Lydia during those long night shifts at the cargo plant, a geological survey firm named Terrascan Resources had spent 3 months running vibro-sized trucks over the county roads adjacent to her land. Their report, a bound document with a confidential red cover, sat on the desk of Red Basin Holdings CEO, a woman named Victoria Klein. Victoria Klein was a predator in silk blouses. She bought distressed rural debt at pennies on the dollar, foreclosed aggressively, and stripped the land of its subsurface value before selling the surface to widowers and retirees who never knew what had been taken from them. The Marrero Ranch wasn't a cattle play. The Marrero Ranch was a helium play, and Victoria had an option agreement with a pipeline company to supply helium to a new semiconductor fabrication plant in Sherman, Texas, contingent on her controlling the rights. At the auction, when Lydia held up the 1973 mineral reservation, Victoria's lawyer immediately texted her from the courthouse steps. Text message, July 19, 2023, 10:22 a.m. Deal stopped. Severed minerals. Surface worthless to U.S. without subsurface. Owner is a Marrero. Clause goes back to a 73 deed. Victoria didn't text back immediately. She was in a boardroom in Dallas. She stared at the phone for a long time, the light from the screen reflecting off the glass table. Then she typed a single word: litigate. The courthouse air conditioning was broken that summer. Judge Elara Whitfield, a 58-year-old jurist with a reputation for incisive rulings and zero tolerance for sloppy paperwork, presided over the Donley County 100th District Court. On July 21st, 2 days after the auction, Lydia Marrero filed an emergency motion to void the foreclosure sale. She didn't have a white shoe law firm. She had a sole practitioner named Elias Crane, a man who specialized in dirt law and whose office smelled of old books and burnt coffee. Elias' argument was simple geometry in a legal wrapping. Under Texas law, specifically the Estates Code and the long-standing precedent of Acker v. Ginn, the mineral estate is the dominant estate. That means if you own the minerals, you have the right to use the surface to extract them. You own the keys to the elevator, even if you don't own the lobby. But PlainsWest Capital and Red Basin Holdings launched a counterattack. Their legal team, a battalion from the Amarillo firm of Dunway, Kessler, and Root, argued that the 1973 deed wasn't valid because the mineral reservation had never been properly recorded in the surface chain of title. They argued the doctrine of after-acquired title, claiming that when Tomás acquired the minerals through probate in 1974, he was already the surface owner, so the estates merged, destroying the independent reservation. Elias Crane stood up in the preliminary injunction hearing on August 3rd, his knees popping audibly in the quiet room, and walked toward the bench with a document the size of a road map. It was a copy of Tomás Marrero's 1974 probate inventory. The inventory listed the surface estate, 160 acres, and the mineral estate, 160 acres, as two separate line items with two separate tax ID numbers for 50 consecutive years. Your Honor, Elias said, his voice raspy but clear, for 50 years, the tax assessor-collector of Donley County sent 2 bills to the same mailbox, one for the dirt, one for the deep. Judge Whitfield removed her reading glasses and let them dangle from the chain around her neck. She looked at the lawyer for PlainsWest, a young man in a suit that was too tight in the shoulders. "Counselor," she said, "are you telling me your client's $2.5 million title insurance policy didn't require a search of the grantor grantee index for the name Marrero going back 50 years? The lawyer stammered. Your Honor, standard practice is a 30-year search. And you missed a probate decree in 1974, she interrupted. That's 49 years. Motion for temporary injunction is granted. The foreclosure sale is vacated pending trial. Mrs. Marrero, you may return to your home. Lydia didn't smile. She nodded at the judge, gathered her binder, and walked out into the 102-degree heat. She had won a battle, but the winter was coming. Victoria Klein was not going to walk away from a helium asset worth millions because of a typewriter deed. The injunction was a wall, but walls cost money to maintain. While the case moved toward trial, the $418,000 debt was still sitting there, accruing 11.7% interest. Every month, Lydia was sinking deeper into a hole that, legally, she still owed unless she could prove the bank's actions were wrongful. Elias Crane knew they needed to drain the swamp to fight the alligator. He sat Lydia down in his cluttered office on December 2nd, 2023, a week before the trial setting. Lydia, we have the moral high ground, but the bank has the liquidity. They're going to try to starve you out. They want you to miss a tax payment on the mineral estate so they can buy it at a tax sale. What's the cash status? Lydia's face was thin. She'd lost 15 pounds since July. I've got $1,200 in checking. The Christmas money for the kids is gone.